Okay, so hello everyone. Welcome to day two of International E-Conference on Legal Nexus, Insights and Innovations. I'm very privileged to welcome all of you on this day two, which happens to be on a Sunday evening, and I'm really happy to see this quorum here, who are very keen on spending their weekend in an intellectual way. I welcome wholeheartedly, and I really appreciate you giving time here and being present here on this intellectual platform. Speaking about that, let me have a quick recap of whatever we went through yesterday. So, yesterday, being the first day, the session was moderated by Price very beautifully, and I really loved the way she took all the Indian names. She was really good with that. And I know the effort that she has put behind that one, because being a foreigner, it is quite difficult to take Indian names, but she aced it. And also, all the moderate context and everything, she took it on really good. Followed by the first session was by me about men's right, wherein I emphasized about the rights that are there available for men, and also the myths that are surrounding the fact that the men are sidelined and there is no scope for um, protection of men in the society and all other things. And it was followed by Soumya Datta, who spoke about the online scam. He very beautifully described, or I could say explained, the provisions of uh, IT Act, like with sections, what are these and what are the exceptions, and also the description, essentials. So it was everything. And also, in addition to that, he also explained about the relevant provisions in the other legislations, and his hard work was emphasized in the form wherein he was telling the relevant provision of IPC as well as the Bharatiya Nyaya Samhita, so that the people who are seeing this video even after 1 or 2 years, or who's reading the paper maybe after an year, 2025, 2026, or maybe even after that, could easily connect the dots and could understand that where is the current situation over here. So that is a very appreciable and very commendable, and shows the amount of time that you have invested in that one. And the next session was by Ganesh, wherein he spoke about the online dispute resolution mechanism. He emphasized about the various government schemes as well as laws, wherein they are emphasizing the online mode for dispute resolution, either arbitration, mediation, and other platforms. Along with that, he explained about the hurdles or the disadvantages that the online platform carries. Along with that, he suggested some of the best practices. And yeah, that was really very good and informative. Later, we had a very good discussion about the current laws, maybe the new criminal laws that are being enforced. We discussed about that, and also we discussed about few happening things in and around, maybe around Poonam Pandey, the legal course of action that one can take, and also few other topics related to the current affairs. So, saying this, I would say that day one has been really a great day intellectually. Though the quorum is limited, it was, I could say that everybody contributed for the equal learning. Saying this, I'm very much excited for day two of the session. And in this day two, we have three speakers lined up. It will be started with Kavita. She'll be speaking about e-discovery and data privacy laws, followed by Jaideep sir, who will be speaking about capital market and security laws, and followed by Gokul, who will be speaking about the relevancy of constitution in the current scenario. Anandi sir could not join us due to some issues. Therefore, Gokul will be speaking, and he'll be navigating today's session. So, saying this, let us start with Kavita, and it's my privilege to introduce her to this quorum. So, ladies and gentlemen, please welcome Advocate Kavita. She is a seasoned legal professional who emerged from a small village with a scarcity of advocates during her early schooling, and that motivated her to choose the profession of advocacy. In 2003, she became the first advocate from her village. And by graduating at Shivaji University, Kolhapur, Maharashtra. Subsequent achievements include diploma in medical jurisprudence in 2004 and valuable internships till 2006. With overall 20 years of experience, she has established a reputable name as an independent legal practitioner. Academic accomplishments include further master's degree in 2012 from Savitribai Phule, Pune University. As a senior legal advisor, she has collaborated with multinational companies offering expertise in international laws, adapting to the evolving legal landscape. She has upgraded her skills with GDPR certification in 2019. Currently, she is serving as a data protection officer, and her role is crucial in today's focus on data privacy. Notable achievements involve establishing POSH committees in companies and publishing articles like live in relationship, domestic violence against women, and analysis. And also, her career span in the diverse litigation cases, including civil, criminal, family, corporate matters, as well as non litigation areas like intellectual property. She has represented her clients with organizations like SEBI, CBI, CID, EOW, and also at local police station, wherein she has showcased her expertise and relevance. So now it is I could say that a very great privilege to hear about the e-discovery and data privacy laws from someone who is in that field. So it will be a great exposure of both theoretical as well as practical knowledge for all of us. Kavita, it's over to you.
Hello, everyone, and thank you, Kritika, for such a good welcoming speech. Thank you. So, as you already inform or mentioned that I am giving e-discovery and data privacy laws. Yes, it is my right now we can say it is a core subject everyone. So, I am giving that brief for that subject. So, first of all, we start that what is meaning of e-discovery. E-discovery and data privacy laws, we need to understood that what is e-discovery. E-discovery is the main word where term used in litigations where the parties are required to provide relevant information and record along with all other evidence related to the concerned case to each other. As you, we are all advocates, we know that discovery. So for the case, we need to get information. For discovery, we evolve in the digital format, digital world. So e-discovery evolve. So e-discovery is shortly defined as an electronic discovery, which is defined as the process of discovery in litigation carried out in electronic formats. In short, we can say, as we know that Information Technology Act and all that now, DTDPA, DADAPA right now, we can say GDPR. So we know that e-discovery, what is that? So I'm giving elaboration for that. It encompasses what is the most often called electronic stored information. In short, we say that ESI. ESI means electronic stored information, which we are stored in our laptop, in our cloud format. That is called electronic information. ESI but not includes emails, documents, database, voicemail, presentations, audio, video files, we can say social media, web page, and any other electronic information that might be pertinent to relevant evidence in our case, we can say, or in lawsuit. It also included raw data, metadata such as timestamps, author, recipients information, and file attributes, which forensic investigators can review for hidden evidence. There are so many cases, there are hidden format, hidden data, we can say. Some companies, they are not collecting proper format, proper data. So that can be treated as a hidden data, so hidden evidence, we can say. So everything included in electronic format, that we can say electronic information in short. So furthermore, we go ahead, electronic may be necessary following situations: shareholders details, conflicts, we can say internal investigation, regulatory compliances. It includes in e-discovery, acquisitions of intellectual property, infringement, demands of for public records. These included in e-discovery, where we have to, where we can say, we can take an example, trademark infringement. So in that case, we have to take company's data for the discovery, for the investigation, for our case. So that called be as a e-discovery. E-discovery procedure is an important part of modern legal practice and provides in systematic, efficient means to gather. So what is the role of e-discovery? I'm discussing for that point. The process of gathering, preserving, and utilizing electronic material for legal purpose is known as electronic discovery or e-discovery. म्हणजे we can say, for example, we take an XYZ company. Something happened with that company, with that data. In short, we can say it's a hacking data. Already hacked, we transfer, export any data without permission. That how it has been hacked. We need to take a discovery. That discovery we call as a E, because it is absolutely on the cloud format, absolutely in the electronic format. That's why we said that e-discovery. So discovering it needs by who it is needs by. That is more important. Not only that person only discovery that or for that lawsuit. So discovery needed by law firms, corporate legal department, or governmental agencies. Typically contract with the e-discovery professionals. And e-discovery professionals may do the following: help, collect, process, analyze, produce, store ESI, depending electronic stored information, ESI means, depending on the needs of the organization or the individual. Whatever the data we are collecting, that should be processed, that should be accumulated, that should be reviewed, whether it is that accumulated data, it is okay for that case or not. We need to say, we need to analyze. And what are the steps of the e-discovery? There are the almost 6 stages for the e-discovery. How we do or how we follow that e-discovery? First of all, data collection. Second, data transfer. How it is transferred that data, or any company transfer that data. Data processing is more important. Otherwise, everything we are accumulated or placed or stored in the cloud format, it is not possible. Or whereas ECA, we can say early case assessment, there sometimes there is important for the early case assessment we can do, or we can say in short internal audit, we can say we need to do for with the company's data, for the document review or exchange and case termination. These are the majorly important stages for the e-discovery, how we accumulate that data. Next point is how does this e-discovery work? Whatever I stated about the stages or steps e-discovery, how it is processed, how it is work, that I'm explaining. As per the needs and available resources of that organization or any company. This is regarding organization or any company, MNC we can say, where establish an e-discovery process. Every right now in India or any company, everyone establishing e-discovery process. However, the steps are connected and often handled by digital forensic specialists. Yes, it has to be that process or that e-discovery process we need to handle by expertise. No one can be handled that any layman come and I will do it. No, that's supposed to be special training or special expertise to handle it, that data. Map map the inventory, location, collection, or any relevant data or electronic stored information. There are 9 stages for the e-discovery that we can model. We can say that electronic discovery reference model, EDRM. We call for that. There are 9 stages how that e-discovery work in the organization. There are information governances, identification, preservations, So what are the information governance or IG? Information governance is all about the process, policies, and regulations established to manage the company's information. There are so many policies, as you know, that everyone knows that companies having their own policies. That should be in line. It is a we can say asset of that company. So it should be in line with the company's project, company's trade or company's brand. So it is included with the e-discovery, first of all. It focuses on managing electronic store information, ESI, in such a way that concrete evidence is built to cost effectively. Whatever the evidence we go to present in the court, we need to gather specifically. So eliminating the need for company to bear high e-discovery. This is the information governance. Policy should be intact with the organization motive vision we can see. For the next stage is identification. This stage is about the finding the most relevant evidence or data for that case, you can say. And the data is put on legal hold, a process to preserve all form of information when involved in litigation matters. The reviews of inconspicuous and vast amounts of data, including case facts, filtering data, and interviewing KPLs to discover the gathered evidence carried by out the digital forensic teams. Yes, identification means whoever the we employed in the company, that person is supposed to be extra expertise to identification. Whatever the case happened, whatever the copyright, for example, copyrights happen sometimes. So in that case, we need to expertise. For example, from IT expert, that person supposed to identify which is the what is the exact image has been copyright infringed. Is that image has been uploaded from that concerned IP address or not? Who will be discovered? That expertise only. Not me, not you, not any layman. The person who is expert is the person who is understood. It is that image has been infringed from the particular IPs. So identification is more important in the evidence. Further stage is preservation. How we preserve any data in the company or individual. That process has been explained here. Being a party who has a legal duty to preserve relevant ESI or information stored, electronically stored information, and avoid violation means deleting discoverable evidence. This phase primarily focus on the very fact that is facilitating dialogues from the legal team, the custodian to keep them aligned on the best practice to the retrieve discoverable ESI. Means how we preserve that is more important. Everything so, and if we don't have any crucial or particular evidence, there is no need to other data need to collect and preserve. Not necessary. How we collect that is more important. Further collection, yes, this is the second phase we already am discussing. In this phase, the technical skill professionals required for the collection of the data from its native source where we are collecting. That is more important. In every company there is a server, there is a drive, we can say. Now in short, Google Drive. How we can collect that data, that is more important. And that should be collected by professionals only. It is important that whenever the collection means it is taken, the data isn't tampered with. Yes, absolutely. That data evidence should not be tampered. Whenever the cases evolve from the that any kind of case evolve from the company, we need to check that data should not be tampered. Evidence should be preserved as it is. It should be remains unaltered. Further, next phase is processing. How process in this phase more accessible format for the advocates to review and the preserve are done by ESI. Processing means how we preserve. These are stages interconnected, interlinked to each other. E-discovery. So review, production, presentation. The production, as you know that whenever the code data is collected, preserved, collect, and presentation production in the court, it should be the crisp and the particular specific for that matter only, not the every data need to collect and present to the court. It is not necessary. It should be the relevant to that matter, and that should be the done by a or an advocate. Further presentation, yes, you know that the final phase e-discovery happens post-discovery and takes control how, what, and when the ESI produce in a hearing, deposition, or trial or present facts and ensure legal these are the e-discovery stages. How work e-discovery? That whatever the explain, this is the e-discovery. Further, there are so many challenges with the e-discovery. So I'm taking the challenges of the company's face. How company faces the challenges e-discovery. There are standard e-discovery process is documented for business. Primarily, it is based on industry size, there's industry size and nature of the company and data infrastructure. The process can be challenges following ways like data collection, data handling risks, further privacy challenges, record management. So, what is data collection? Again, this is second time we are going to this point because challenges we are facing in the data collection, it is more important. The data retrieval from different resources. In company, there are so many heads, so many departments. But definitely, every department having their own data, and that data company has supposed to be collected. But how and when? It should be the uh, bifurcated, analyzed, identified that data, and all data is not be available to in a compressive format, which makes the process was complicated. This is the challenges. Further handling data handling risk, we can say sometimes conducting and handling e-discovery, the collected and processed data will be lost. Yes, absolutely. Whenever the we data collecting, sometimes it will be happen that data will lost or data destroyed or sometimes inaccurate by any person or any who is handling that. It can be occur. So we need to take more precaution for the data handling. So it will not goes to in a risk manner. So whatever the evidence, it should be intact. In short, further privacy challenges also connected with the data processing or e-discovery. Data privacy more important. Certain legal disclosure laws in places protect against a data breach. Data breach we cannot afford right now, or any confidential information we can't afford. So these are the challenges. The organization is essential to abide by a data protection or retention policies. Yes, every company now they are applying data protection policies, say, or retention policies, or that retention should be limited. It should not be long. These are the challenges. Sometimes it is happened because due to we can say as per the according to law we need to explain to the court, or we need to transfer that data to the concerned person or to any government agency. That time also we need to take a consents of that person or any company that we are trying to transfer this data. These are the challenges. Sometimes some people will not available for the consent. These are the challenges. Further, record management. This is also a more important aspect for the challenges for the e-discovery. In the ongoing legal cases, throughout the process e-discovery, it is necessary see that the data record collected are accurate and consistent. It helps safeguard and involve organization against suspicious about the alteration or deletion of data that might be relevant. Avoiding discovery disputes as a result misunderstanding, suspicious or miscommunication should be goal of both parties. It is avoiding discovery, you can say that it should not be misunderstanding. It should not be suspicious. And we cannot say that people or other party will not suspicious or misunderstood everything. That should be the challenges minimize. And these are the challenges. Further, we can going ahead, e-discovery automation is another one point right now evolve. every year, we can say 2020, 21, 20 till COVID, there is a data collection format is in the office and all that. But from the COVID, we everyone goes in the online. So absolutely the data going to automation format. So this is challenges covered from the challenges and opportunity. What is e-discovery automation? Evidence-backed arguments sway trial verdicts, we can say. Therefore, it is not surprising that lawyers invest a significant amounts of time and resources to gather evidence ahead of a trial. Normally, evidence is present in various formats such as interrogations, confessions, depositions, and documents. Legal parlance means the process of gathering the data. Today, e-discovery more evolved due to electronic capture and stored evidence. An offshoot of digital information is the data mismanagement. There, however, digitalizing discovery alone is insufficient in automation. The National Judicial Data Grid estimate that 69,000 cases were pending in the Supreme Court of India as of February 1st, 2023, and over 59 lakh cases in high courts. Therefore, the technology of e-discovery has arrived. Why I'm telling you the automation is how it is important, how it is challenging, that is I'm explaining. The tremendous growth of electronic stored information and the complexity evolving e-discovery case for adoption of advanced technology like content management, machine learning, or AI or MI, we can say robotic process automation, RPA, based and artificial intelligence, and natural language processing. One prominent example we can say technology assistance review, TAR, an automation tool that serves during e-discovery review. TAR assists lawyers in collecting, reviewing, and classifying documents at the early stage of case. This aids in the strategic client advice and case organization by prioritizing critical documents and facilitating strategic defense development. TAR enable efficient decision making. Its capabilities in providing statistical analysis, categorization, and comprehensive reports surpass human-only review capabilities. What means that the technology that analyze reviewing fastly beyond the human review. So we are accommodated that new invention, we can say, or new digital format. So these are the e-discovery. Whereas the challenges how we can face more than automation, complexity of the data source. Complexity, there are so many modern data sources are diverse and complex. They are present on premise in the cloud or social media. As we know that there are so many social media formats. So whatever the data we are accumulate in the huge volume, we can say. So we can't accumulate everything from every platform. So it is challenges for us. Automating this automation, identification, collection, and processing data from this source will be needs specialized tools and techniques. For the huge data, we need to more tools for the accumulated data. Volume also is more important, and we can say volume is not simple or crispy. So that volumes needs to be bifurcated particular format, and for that we need a tools for the data quality and variability. Data is prone to errors, inconsistencies, and incompleteness, posing challenges to automating data categorization extractions. The complexity depends when dealing with the diverse data format and language. Legal and regulatory complexity. Yes, this is another complexity for the e-discovery automation. E-discovery automation needs to adhere to legal and regulatory requirements governing confidentiality, data privacy, and preservations. Careful consideration and appropriate safeguard are required to balance automation efficiency with the legal obligations. What is mean that legal and regulatory compliances needs confine the confidentiality of that organization, a individual or customer or any kind of vendor of that company. No any legal regulatory compliances say that yes, you have a right to export any kind of information to anybody. Not at all. No, not to third party, not to any other country, we can say, or not to any company. So we need to take off that. We need to take what we call that importance. We need to understand importance of the informations. Without anybody's consents or voluntary consents, we cannot transfer your information, anybody's information, to third party. Further, evolving technology, keeping up with the technology advancement and ensuring compatibility and integration with existing systems requires continuous learning and adaptation. This can be a challenge. Yes, as we yesterday discussed, for example, the name of the our acts. Yes, we need to take challenges and need to adapt that. Like that, every new technology need to adapt with us. Further, harmonizing automation and human participation. This is also important for the automation, e-automation, e-discovery automation. E-automation tools are not infallible. Therefore, human expertise and judgment remain crucial in e-discovery. To ensure accurate and reliable results, it needs an optimal balance between the amount of automation deployed and the human involvement required. These are the challenges for the e-discovery. How discovery is and how is evolved, how we can accommodate it, and how what are the challenges. This is the e-discovery. So I'm going to ahead with the what is data privacy. So why I'm telling you that for e-discovery there is a data is important. Which data, what data, how we can handle it, that is recover in the data privacy. And what is data privacy is more important. An individual's right to privacy is protected under various laws and constitutional rights. In simple terms, it means that unless you give your permission for information to be made public, that information should be kept private or your personal, we can say. So this is the privacy, right to privacy, we can say. Therefore, there are some exceptions there where we can say that this is a right of privacy. I cannot give my information that where the ask the what are the exceptions require that information required by the law or government agencies like a court or we can say any court case. Sometimes expertise like PDS, ITR returns submission, we can say, or as a tax expertise come to the court to give a particular person's particular investments details. So that time we cannot say that yes, this is my personal assets and personal information you cannot give to the court. But according to law, we have to, or that time that tax consultant or expertise who is appointed for that purpose, that can be informed give to the court. Data privacy means when dealing with the e-discovery, there are sensitive pieces of information involved in legal cases. If handled improperly, it could be potentially cause harm, which is not good for anyone. Yes, that e-discovery, e-data should be handled properly and very meticulously. It should not be disclosed or it should not be publicly exposure. Otherwise, it's hampered to that person, hampered to that organization, or hampered to anyone who's that sensitive information disclosed to the publicly. What are the some concern about the privacy violations? Where I'm giving to what are the violations? There are two main concerns about the privacy violations. First is what happens if there is a data breach. and personal data is stolen or released. This could be a minor as a hacker gaining access to your website, we can say, or as a major as a state sponsor attack on your company. Yes, as we are taking example of company, it can be hampered to the company in a major way, or as an individual we can say, see, my name is Kavita, so if I am allowing to Kritika to use my name, then and then will Kritika use my name without my permission. She cannot give any kind of explanation, my name or any information which is very sensitive in for me, that should not be Kritika exposed to the public unless and until I'm giving permission to her. This can be uh, hard to me or any kind of cause or harm to me. Our second concern, when you accidentally violate privacy policy laws by mishandling information during e-discovery. There are so many chances that whenever we are handling data, privacy will be violate. So how we can that violation can be compiled, or it should not be. We can prevent that data. That is more important. So what can you do to prevent data privacy violations? Being aware of the personal information of you have on file and keeping it secure is crucial. If you do not want your data used or shared without your permission, then make sure you are not doing any of following things, like don't provide too much your information to social media. Further, be careful with your email. Free sign up for a trial that requires an email address is not advisable. Do not use public computers to access sensitive information. Sometimes we are using public in computer for the bank transaction, so do not use that. Change password oftenly. Before downloading an app, please check privacy policies. Yes, this is also important, very important point. Whenever we are clicking any kind of form online, we never ever read that privacy policy. But it is my recommendation that please read it. Sometimes it will be against to us. Sometimes it will be fine to us if we are not reading. So it is advisable we need to read it, privacy policy. Sometimes, so many times we are not even bothering to read it or check it what it has been written. Actually, privacy policy is an agreement on the online format, so we need to read it at least in one website. You can read it, you will understand what it has been written. Okay, use a different password for each account. These are the clues, or we can say how we can prevent data privacy for the against violation. Now next, going to point that what to do in case of a breach. Though we are taking care of all those things whatever I explained right now or mentioned, still there is a breach, data breach. So what we can do for that breach? When you suspect that your private information has been accessed without permission, you should contact the concerned expertise or department of the organization. Yes. Why I'm giving an example. There are conference, there are exhibitions like this conference. This we have mentioned our personal information. But sometimes, as yesterday Kritika mentioned that Juhi's example, Juhi Chawla's example, she gave exposure to the publicly. So this should not be happened. In that case, the concerned person, concerned department, we need to contact that this thing happened, and I think my personal information goes publicly. That should not be. So we can prevent that if it is a minor. And if it is in on major platform, as court took as contempt of court in Juhi Chawla's case, that can be happened. If there is a breach in medical record or health insurance information, call to healthcare provider directly. Yes, sometimes this happen. There are so many ways to gain money. So people are hacking data. I think if I'm wrong, or maybe this is my information, that one of a bank hacked by someone, or every data has been hacked that person, and he's saying that 500 crores he wants against to data. So this is very much serious point. I'm not taking which one the bank, it is renowned bank. So somehow it has been settled down and everything intact right now. But this happened. So every crucial sensitive information can be problematic to us, or problematic company, or problematic country too. So we need to take care of. So how we reduce this risk? There are so many ways you can reduce your risk in privacy and e-discovery. Some of them are general, storing less data or only saving data that is relevant to your business. This is concern for the companies, like doing backup, while others are specific in your situation. In a good practice of reducing privacy and e-discovery risk, which will pay off if you ever need it. In most cases, during the early stages of e-discovery, the organization have more control what happens that they do ever what happens during the latter stages. For example, an organization might decide not to collect certain types of information at all, or simply not save certain information as a part of its regular operations. If there is no data has been collected, preserved, then there won't be any left for later stages. Yes, we can say if any organization collecting particular data, it's okay for their relevant trademark, copyrights, intellectual property. It's okay. There is no need to everything collected. Sometimes relevant data is more important. That's it. We can collect it. Further, the issue of data privacy is growing concern as the generation storage, electronic store information continue to increase day by day. The challenges handling digital evidence will only increase as companies expand their use of artificial intelligence, and it is risky. Yes, this is an important point, that every time we cannot use artificial intelligence. We need to expertise. We need to employ that expertise for the particular evidence, particular data. And in litigations, often sensitive information is involved, making data security a top priority for corporations and law firms during e-discovery. E-discovery also plays a role in internal investigation, shareholder disputes, regulatory compliances, audits, and trademark infringement claims, further highlighting the importance of data protection and privacy throughout the e-discovery process. E-discovery process, which involves collecting, copying, transferring data outside of an organization, raises significant concerns about data protection at every stages. ESI often contains confidential data of the company, which is vital, such as trade secrets, information, and data. An advocate needs to be aware their obligations to protect this information and prevent unauthorized disclosure like hacking, malware attacks, and internal security breaches can compromise ESI, leading to unauthorized access and misuse of sensitive information, which is not affordable to any organization. Additionally, in case individual data will be collected, used in legal proceedings through ESI, it raises privacy concerns. And that time, advocate must be mindful of their client's privacy rights and take steps to protect them. Here, not only organization is required to take care of the data, but advocates also to take care of the data of his clients and companies. So further, I'm going ahead, how we collaborate or navigate e-discovery and data privacy. How both are goes with in hand. That is more important. So what is the e-discovery? What is data privacy? It is okay. But we need to collaborate with each other. Otherwise, the purpose of data privacy will not we will not achieve. So in today's legal landscape, e-discovery is a crucial component. This process involves so many steps: identification, collections, analysis, etc. Whatever I explained earlier. As we continue to transition in the digital age, the reliance of e-discovery grows exponentially. It is pivotal, helping in unpartial evidence, enabling a comprehensive and accurate representation of the case at hand. Whether it's emails, text messages, social media posts, or business documents, e-discovery can extract and preserve these digital data trails, fundamentally in the way legal proceedings are conducted and often tipping the scales of justice. Though bearing significant legal and ethical implications, data privacy stands at the forefront of e-discovery information considerations. A failure to uphold stringent data privacy standards can lead to a breach of sensitive information, damaging reputation, and potentially resulting in hefty legal penalties. Therefore, there are some data regulations, such as general data protection regulations, become increasingly stringent. The importance of careful, considered approach to data privacy within e-discovery process cannot be overstated. In essence, respecting data privacy isn't just an optional facet of e-discovery. It's a vital requirement that enables legal professionals to perform their duties without breaching trust or violating legal status. E-discovery process works in several stages. So we need to take legal and IT teams who determine where the relevant data might be stored. Potential sources identified. The next stage is preservation. Begins data is protected from the deletion or alteration in the stage of preservation, and it is crucial as it ensures the integrity of potential evidence. Following this, the collection stages begins with the identified data is gathered. It has to be done in a way that maintains the data's original state and preserve all metadata. After the data is collected, the processing stage begins. Here, the data is converted into format suitable for review and analysis. These stages helps and often involves removing duplicate data and making the data searchable. The review stages comes when the gathered data is examined or relevance and privileges. Advocates often use review platforms that allow them to search the data, tag it, and redact sensitive information. Finally, the last step is production, where the relevant and non-privileged ESI is handed over to the opposing counsel, usually in a mutually agreed upon format. Throughout this process, a chain of custody must be maintained to ensure the data can be accounted for in every stage. However, the advent of robust data privacy regulations such as GDPR in the European countries or Union demands stringent controls over how data is managed. This is a delicate balance of work to be struck between the requirement to protect personal data privacy and the need for comprehensive e-discovery. Organization must ensure that the process of collecting ESI for e-discovery purposes does not infringe upon an individual's right of privacy. This balance can be challenging between the e-discovery and data privacy to achieve, but it is not impossible. With the data management strategies and technology, organizations can conduct effective e-discovery vessels complying with the data privacy policy, thus ensuring that personal data is treated with the respect and protection it's deserved. It means that whatever the data you are collecting from individually or organization, you need to be protected. And for that protected, laws and regulations relating to data privacy in e-discoveries are GDPR, General Data Protection Regulations in European Union, which imposes rigorous rules on the collection, storage, and processing of personal data. Further, GDPR mandates that organization must obtain explicit consents Yes, I already explained that you need to get consent of that particular person whenever you collect the information from the individuals before handling their data, and provides individual with the right to access, rectify or erase their data. Sometimes I can say that Kritika, please erase my name from your conference or from your data. So this is my right, which is given by the GDPR. Not even GDPR. In India, we have a right under Information Technology Act. Sometimes privacy can be violated. So every person is having a right to that to accept that data, to erase or to, we can say, amend. Sometimes I can say that, Kritika, please rename my name from Kavita to XYZ. So these are the right given by the regulations. In further in the United States, there are so many states, as you know that. So in every state they are having their own laws. Like in Maharashtra, we have a different laws particular state. In Karnataka, there is a particular rules and regulations, same as it is in United States. So they are having federal rules of civil procedure, FRCP, governs e-discovery, specifically rule number 26B1, outlines the scope and limits of e-discovery and permitting the discovery of electronic stored information that is relevant to claim or defense and proportional to the needs of the case. Further, various industries specific regulations such as Health Insurance Portability and Accountability Act, HIPAA, for healthcare, and the Sarbanes-Oxley Act for financial services also have implications on both data privacy and e-discovery. These laws underline the necessity for organization to adopt comprehensive data management strategies that can be navigate the integrate legal landscape effectively. Yes, they are giving some strategies, rule regulations, how they can handle particular person's health information, which is more sensitive, like financial information. It is as good as the health information is more sensitive. So these are given regulations or rules, implication, how to implement, how to gather data. Further, in India, we have the Information Technology Act 2000. Also, Indian central government passed its long-awaited Digital Personal Data Protection Act (DPDPA). That is still undergoing process. It is not implemented all over in India, but they are trying to on the we are trying to, or we are borrow same definition as per GDPR, General Data Protection EU's. So aims to protect data principles and restrict the activities of data fiduciaries. These are the laws where we are confined our information should goes viral or goes publicly unnecessary. Otherwise, law or court can uh, impose hefty penalties. So this is the protection given by the courts. Maintaining data privacy throughout the e-discovery process is not only legal obligations, but a fundamental requirement for preserving the integrity of the individual and the credibility of the organization. Breaches in data privacy can result in reputational damage, severe penalties, and loss of customer trust. In an age where the personal data is often compared to a currency, organization must be demonstrate their commitment to privacy by implementing meticulous data handling procedures. This is particularly crucial, a process that necessitates the collection and examination amounts of electronic stored information. By safeguarding data privacy, organizations can fulfill their legal duties in responsible manner, reinforcing their reputations as trustworthy custodian of personal data. Yes, data privacy should not be violated, anybody, anyone, and if they are doing legal duties, give a trust that they are trustworthy organizations and they are handling properly their personal data This should be the message goes to the concerned person. Further, expertise in cybersecurity and e-discovery and data privacy. This is also is important point that in digital area, the intersection between the e-discovery and data privacy is not only the noteworthy but also regulatory necessities. Understanding this connection is a crucial for business to operate ethically and legally. E-discovery process require carefully handling a data, often sensitive and misleading, can lead to significant data privacy infringements, resulting in not only reputational damage but also hefty penalties. Therefore, businesses must navigate this complex landscape with utmost precision. This is where the importance of professional assistance comes into play. Navigating the complexity of e-discovery and data privacy is like walking to tightrope. One mistake can lead to significant complications. By using professional help, business can ensure that they are abiding by data privacy policies and laws during the e-discovery process, thereby safeguarding themselves from legal ramifications, ensuring transparency and trust with their clients. This is not just a recommended path, but an intelligent business strategy to seek professional aid in managing e-discovery while maintaining data privacy. At the end of this topic, I'm giving a conclusion that e-discovery and data mining is steadily improving, but data privacy is enhancing the guiding rules or laws that do not meet litigation or investigation demands. You or your advocate should understand the compliances needed to avoid data breach that are not permissible by law. Be intentional and plan to avoid facing data breaches issues during litigations or business transactions. That's all. This is
Thank you,
about the,
Kavita.
yes,
Yeah. Okay, so before anyone could start, I have two questions for you. So
yes,
you told about the right to privacy and the breach part and the data part. So
correct.
in Karnataka, government of Karnataka has introduced a scheme wherein it has provided free bus facilities to women. Okay, but it has given a condition that we should provide our Aadhaar card or voter ID and show that we are having the domicile in Karnataka. That is that Aadhaar card or voter ID, what or in a document that we show should have the address of the Karnataka state. In that circumstances, we will get the exemption from paying the bus ticket, so we can travel all over Karnataka free. Now, my question here is, see, why should I show my Aadhaar card or my voter ID to a conductor in the full rush bus? Okay, the conductor is not just knowing my address, but he will be knowing my father's name or my husband's name, or he'll be knowing my phone number. Along with that, he'll be knowing my date of birth. And not
Correct.
just him, suppose it cannot, I cannot ensure that I am always with a female. Somebody male would be sitting behind me, and when I'm holding my Aadhaar card, he can quickly take a photo of mine and he can have the phone number. So isn't such government regulation which is asking the public, that to a female, so I'm not playing a female card, but still they are the most vulnerable sector in the society, to show their uh, ID cards or documents in the public space, isn't it an attempt of a data breach
Yes,
or violation of right to privacy?
yes, yes. It is a violation of privacy. It is a data breach, we can say. So anyone can
Mhm.
see senior whatever the information, father, mother's name, and birth date, and etc. etc. Yes,
Phone number
actually,
too.
whatever you have written on Aadhaar
Yeah.
card, for example, yes, it is a breach.
Mhm.
And at that time, if you are pointing this such kind of issue, it means I address to the court, address to the concerned government. Though it
Mhm.
is a government agency, the bus we can say whatever but conductor and driver, they are not asking, they are not concerned person to ask you, not at all.
They
And
ask, they ask. It
no,
is,
in
it is
that
authorized. The government has told in the official notification that we have to show them, and not to soft copy. We have to mandatorily show them the hard copy.
hard copies, yes. In that case
Yes.
you need to take actions for that, because it is a data privacy and data breach of data privacy or right of violation of right of privacy. No one
Okay.
can see your personal information in public, not at all. It is a personal, it is a very much sensitive information, and you cannot show
Mm.
it if you are not comfortable showing that information, or anybody is not comfortable. So it has to
Yeah.
be objected. Object, you need to take objection, you need to implement amendment in that notification, you need to take amendment. It is a
So this
violation.
was questioned in Karnataka government by someone, and the government said that okay, you show your masked Aadhaar card, but still the question remains
No,
open.
yes,
Why should I
yes,
show? Why should I tell my address to someone?
that,
Suppose if there
yes,
is
that.
someone who wants to follow me or harass me or anything, then he has my address ready made with him.
Correct, correct. If we are saying that do not show any, do not give any ever information to publicly, it means that
Mhm.
every sensitive information should not be goes on platform, whatever the in oral format, express format, or implied format, or we can say social media. Not at all. It is not acceptable. And for that,
Yeah.
whatever the we are government is implementing on the line of GDPR, they are implementing or they are
Mhm.
restructuring data protection regulations. So what is the information
Mhm.
is included privacy, private, or what should not be private? They are bifurcating. So that's why we are not still not. It is that act is not implementing immediately. It was expected in the year 2020-23, but still we are drafting that act, which should be
Yeah.
included as a private information, personal information, and sensitive information. There are so many bifurcations. So for that notification, whatever you said, rightly said, that it is a data breach. You cannot show your personal information to any person.
In public platform, in a bus.
Yes, in a bus, and
Yeah.
there are rush bus.
Yes.
Yes,
It's
no,
a
it
it's
is
a rush bus, and I'm holding my Aadhaar card. See, I cannot keep it in my
yes,
bag and try
correct,
opening it. What if I don't get a seat? I have to stand and I have to hold it in my hand.
correct.
Yeah, and
No,
my second question is the thing that I will be always crying about is about the social media trends. Okay, so usually what happens is they do video in public platform, wherein I had seen one video wherein one girl was dancing in the Mumbai train and one man was looking at her all mesmerized and they were focusing on that man. I am like, bro, he has a family. He may have a wife. He may have a daughter. All of them would be embarrassed. Don't do this in a public platform. And also
mm,
somebody coming, somebody going, and these days this traffic officers also what they do is like they show everything, like what they did. Even they have started like things like vlogging. See, this bike man, I stopped, I gave him all this advice. And also I myself have faced this. Once I was enjoying pani puri all by myself, and some vlogger, he was all focusing on me, like, see, she's eating pani puri from that food stall. He was reviewing that. It was such an embarrassment to me that I couldn't eat the food. And also, even in the flight, I have experienced this. Once I bumped into a content creator. I don't know who she is in the flight, and she was recording everything. Unfortunately, she sat in front of me and she was doing vlogging. She was explaining to her this one, she was recording videos, and I was in the frame. She was not at all bothered to ask me that are you okay to be in the frame. And when I told her I'm not okay to be in the frame, she made me feel that, and also everyone feel that I am rude for refusing her uh, to be on the frame. Like, what if I am some person to be refusing to be on her frame? She made such faces. So in that constant context, would that be also considered as a breach of data?
yes, yes, of course we can say. See, publicly what you want to say, what you want to not to say, it is your right. It means
Mhm.
that no means no, it's not a
Yeah.
yes. Yes. So we can categorically we can say that it is a data breach, but it is a breach of your personal or private space, and it is ethically, morally, legally against to your privacy. So we can say that, and no
Yeah.
one
Even
has that right to go and come unnecessary or forcefully come to that frame and just say that hi and hello. No, not necessary. Nobody is, not everyone is okay with the video. Me too also not okay with the video. You have to take a consent, you have to take a permission from that person or for that particular video. Then and then only it can be happen. Otherwise video it's absolutely for the publicly will be shown.
yeah.
So what we will do? So in that case, publicly, I'm not comfortable, or you are not comfortable. So it can be
Mm.
data. We can say breach of your privacy.
Yes. These
Yes.
days, if you say no to things when somebody is filming you, then you are the most rudest person alive on the earth. They make
No,
you feel so.
frankly speaking, I'm not comfortable with the video. Even I'm
Yeah,
not
neither
today,
me.
I'm not on the social media. So what we will say? So I'm not
Yeah,
comfortable with these things. So
neither
everyone
me.
is having their privacy. They are handling privacy, or I'm comfortable with the face to face. That is more
Yeah.
important. But how much I want to explain any kind of personal information, that is up to me only.
Mhm.
It's not you that, yes, Kavita, you need to say something with the video. Not at all. If I'm comfortable, okay, I'm comfortable.
Yeah.
So that whatever the show videoing your whatever the frame they want to take a frame,
Mhm.
in that case, if you are not comfortable, they're supposed to stop over there. So I said that no means no. It's not a yes indirectly.
Yeah.
Yes.
Yeah. Anyone has any questions for Kavita? So I'm done with the two questions that I had.
Yes.
Yeah.
Ma'am, to what extent will the Digital Personal Data Protection Act uh, impact e-discovery in India?
Oh, there are so we can't we can say that how much that much there is so many platforms, and e-discovery impacted so many platforms. Not only this video, not only the social media. There are so many type of collection of data. So we need to take, for example, WhatsApp. There are so many chattings. Initially it was good, but sometimes it is happened very vulgar level. So it can be both girl, for example, a girl and boy chatting initially good in a good way, in a very healthy manner, but sometimes they involve, sometimes they become a girlfriend boyfriend or whatever that they choose as a partner in future, and sometimes they got a breakup. In between whatever the chatting happen, it can be the taken as a e-discovery in living in relationship, or in a husband and wife's case, or even client and organization, we can say in any organization initially. For example, this Kritika's conference we can say is as an organization, company, organization as a company. So we mention our name, etc, etc, sorry, main name, age, gender, what I'm doing, everything I have given to the Kritika. But
Mhm.
after sometimes I'm not comfortable that I can say that Kritika, please do not give my details to anybody, XYZ, whatever the Somya asking for that my details. So if I'm not, if I'm rectifying or if I'm not giving that access, in that case, Kritika should stop that information with her, or for example, for particular time. If I'm saying that Kritika, for after 5 days, if I'm asking today that my details should not be given to anybody from today to till 5 days, after 5 days it should be returned to me everything, and it should be returned, it should be deleted from your data. It means that she's supposed to do it. And there is exception, which whatever I explained, that whenever the, if Kritika and I have any legal matter, in that case Kritika can use that in an exception case. She can say that yes, for the legal purpose I kept Kavita's data only that purpose, for the legal purpose, and court asked me to release. And for that, she can say that, Kavita, I'm giving so and so. If we are not contesting to each other, then she can inform me that, Kavita, I'm giving your details so and so and so. But we are contesting to each other. In that case, she can file an application to the court and say that, yes, I'm having this information about the Kavita. This is the scenario of the e-discovery. For that, she supposed to maintain what should be the recovered data.
Okay.
Anything else? I think Jaideep sir would like to ask something earlier.
Wanted to, I think Kritika has covered that, but nowadays
Okay.
there are so many news about stolen of data of
Okay.
so from my social media platforms, say Facebook,
Mm.
as you know,
Yes.
millions of data have been stolen, and I
Yes.
then subsequently what happened, even no one knows.
Ah,
Yeah.
as per my knowledge, what I'm having knowledge till now, they are storing on the cloud, and they are freezing all those data, whichever they're not using repeatedly. Whatever the repeatedly, they goes viral and they goes publicly. But what should publicly go, that depends on that person only.
And it has happened not only in India, it has happened in USA
Everywhere,
also.
everywhere,
Mm.
everywhere, everywhere. Worldwide, we can say.
Yes,
That's why the GDPR and our data protection regulations going on still.
going on.
And no one exact, no one know idea of that data, what we will do to next day,
Mm.
next level. No one has idea.
True.
So we are taking care of that. The data should be protected. That's the only purpose right now. It should not be goes hack or stolen or misuse, in short.
And also, one should be very careful while allowing permissions or
Correct.
allowing the cookies. I think that is
Agreed.
some of the greatest thing, like because most of the apps they ask access for contacts. So I don't
Content.
install such apps which ask for access to contacts. I am okay. I am not even okay to give access to my gallery because I feel it a little skeptical and I take aback. Like, why my gallery? That's
Correct.
something scary, right?
Correct. Correct.
And
So that's
contacts,
why we
no,
have
that's a red flag for me. I'm like, no, I am not downloading and installing this app, whatever it is, however it is.
correct.
And sometimes camera access is and gallery access becomes inevitable. Like phone pay, Google Pay will have to give access, right?
Correct. Correct. So that's why we should more careful. We need to check thoroughly whether it is okay or not. That's why I'm recommending. Please read privacy policy of that
Yeah.
particular app. This is very much advisable. It is explain everything, but we need to check it whether it is only for that particular purpose, or
Mm.
whether it is marketable, whether it is not, or whether it is goes to other third parties website. If it is, then do not accept it. It is advisable by me.
Yeah. I totally agree with you on that one. And also
Correct.
sometimes it asks access for microphone. I think from there they hear our conversation and show everything, whatever we talk.
Correct. It quite possible. So we need to more careful for that.
Yeah.
And technically, these people are very much ahead. What we are thinking right now, they are thinking beyond that.
Right.
Almost means today we have WhatsApp. I think there are so many apps has been evolved already. So they
Mm.
are trying to, when it will the play it, we will the publish it. They are trying to
Yeah.
it. Yeah. Like Instagram and all that. Actually, I don't have
Mm.
any idea about the Instagram and all that because I'm not on that platform. These are platform are not meant for me, I think so. So I'm scared for these platforms.
Mm.
And
So everything goes on viral.
another menace is receiving unauthorized links. Nowadays, so many
Mm.
links everybody is getting. The moment you click on the link, your money is gone. from the bank.
Yes, yes,
Yes.
yes,
That is
that's
another
true.
big issue.
Even one number is has been incorporated, that hashtag 401. You should not be click that on that number.
Okay.
The yes, that number should not be clicked. Hashtag 401. They are saying that this is from bank and so and so and so, and we think that, oh, this is genuine, but do not click on that number or click on that link. We have to be very, very, very careful nowadays.
Yeah. Any questions from anyone before we move further? Okay, I don't think there are no more questions. It was really thoughtful, Kavita. Like, you spoke both in the perspective of a company as well as in the perspective of an individual. I think that caught my attention a lot because I learned it from both the ways. Both the ways, things are quite different. For a company, data is different. For an individual, data is different. So you covered both the aspects and both the perspective. That was really good. And those best practices, I will try my best to implement this and read the privacy policies, look at the source of the app, and understand whether that app is required to me or not, and all other things I would try to do it my best. Thank you. Thank you so much. And yeah, moving further, we have Jaideep sir who will be speaking next. He is an qualified lawyer from University of Mumbai, and he is a qualified independent director certified by Indian Institute of Corporate Affairs, and he's a dynamic professional with extensive experience, nearly 34 plus years in legal and secretarial, corporate and general affairs, having expertise in the areas of corporate legislations, drafting contracts, agreements, legal compliance, and whatnot. He is a very keen analyst with exceptional skills in litigation as well as non litigation matters. He is an advocate on record of Bombay High Court as well as that of the Gujarat High Court. He regularly appears before High Court, District Court, both in Mumbai as well as Gujarat, NCLTs, DRTs, SEBI, SAT, RERA, and consumer forums. He advises on legal matters to domestic and non domestic companies. He has been actively coordinating with SEBI, NSE, BSE, and other statutory authorities. His law firm, Lex Street, has also started GST litigation and advisory practices in Mumbai and Gujarat region. Educationally, he has graduated in commerce from Bharatiya Vidya Bhavan, University of Mumbai, and is law graduate from prestigious KC Law College, University of Mumbai. He has also completed his LLM in business law, and he is an NISM certified professional. So he started his professional career in 1989 as a management trainee in legal department with Atul Limited, and since then he has never seen back, and he has worked at the major portfolios covering capital market and IPO register, and also in security laws, corporate laws, FEMA, commercial laws, and all other perspectives. And also, once again, to reiterate, he's a founder and promoter of Lex Street Advisors LLP, advocates and solicitors, full service law firm. And today we have him to speak about capital market and securities law. Again, I would like to say that he has a good hand on both theoretical as well as practical knowledge. And again, I'll reassure everyone that it would be a of great learning for you, though if it is a new subject or an old subject. He's a very good speaker too. I have heard his lectures quite a few times with IIPS India itself. So he's a very good speaker, and again, happy learning to all of you. And sir, welcome, and it's over to you.
Thank you, Kritika, for a wonderful introduction. And my today's topic is capital market and securities laws, which I think many of are going away from it. People think it is a speculative business, but it is not so. So first of all, I thank you once again. And coming together by 10 people on this platform on Sunday evening is shows our commitment to the profession. So thank you once again to all the participants. And it is said that a journey of 1,000 miles starts with a single step. So starting this step will definitely take us to a long journey in the days to come. So let me start with the overview of the capital market. As you are aware that our previous year's budget, the union budget for the financial year 23-24, I am not talking about current budget, last year's budget, presented a blueprint for India at 100. That is, we are now celebrating Azadi Ka Amrit Mahotsav, and we are, as India strives to become a developed nation in the next 25 years, that is 2047, which where we will be celebrating Azadi Ka Amrit Mahotsav. India will be completing 100 years of independence in 2047. So in that circumstances, as India strives to become a developed nation in the next 25 years, the role of capital market assumes great significance to support the growth through facilitating investment. After emerging from the multiple shocks of pandemic, our country is now well positioned to tread the path of high and sustainable growth. The thrust given by the government to capital expenditure in this year's budget, that is 23-24 budget, through highest ever allocation is supportive of this vision. With a significant improvement in the balance sheet of corporates, as today I see that the company's performance, balance sheet and profits are keep on increasing. We are talking about good companies who are strictly following the corporate governance norms. So with a significant improvement in the balance sheet of corporates and with higher capacity utilization levels, even private sector investment is ready to take off. The investment-led growth strategy is the most suited model to achieve India's potential growth, given the multiplier effect it has on the economy through employment creation and productivity gains. The contribution of the capital market in this growth journey is undisputed. It is the vehicle of growth which help in channelizing resources for productive investment. The various segments of the Indian capital market, namely the equity market, including derivatives and corporate bond market, have witnessed notable growth over the years. This has supported by many regulatory changes brought in by SEBI to reinforce market confidence and make the market infrastructure robust. So this is the overview of the Indian capital market. And with that, let me come to uh, the growth of the drivers of capital market. So I will be speaking about one of the very beautiful concept which very recently the market regulator SEBI has introduced, and that is called the social stock exchange. So I will be deliberating on that little later. But before that, let me now come to the drivers of capital market. So who are the actual drivers of capital market? Of course, investors community is in the forefront. So let me talk about who are the drivers of capital market. So stock exchanges. So now in India, there are only two nationwide stock exchanges, we call it. One is National Stock Exchange and another is Bombay Stock Exchange. So stock exchanges, mainly NSC, BSC, clearing houses, depositories are all market infrastructure institutions. We call it, in short, it is called MII, Market Infrastructure Institutions, which play a very vital role in upholding the nation's economy. So in 2022, the Committee on Strengthening Governance of Market Infrastructure Institutions submitted its report to the SEBI on the recommendations to strengthen governance norms at MIIs. So the prime MIIs, the seven MIIs we call it, which exist today, that is Bombay Stock Exchange, number one. Number two is National Stock Exchange. Number three is Metropolitan Stock Exchange of India. Fourth is Multi Commodity Exchange, MCX. Fifth is Central Depository Services, CDSL. Sixth, next, National Securities Depository Limited, NSDL, and MCX, Multi Commodity Exchange Clearing Corporation. So, as per SEBI, these institutions are in the nature of public utility infrastructure service providers in the securities market, and hence they constitute the key element in the economic growth of the country. So some of the recommendations of this committee in brief, if I have to tell you, functions of MIIs are to be categorized into three verticals, mainly critical operations, that is regulatory, compliance, and risk management, and other functions including business development. So in terms of resource allocation and utilization, the functions under the two verticals, mainly two verticals, compliance and risk, should be given higher priority by MIIs. Now, some of the key elements of this committee, with the committee which who recommended. So, one is to ensure greater independence of the board of MIIs, that is, market infrastructure institutions. The committee said at least two-thirds members of the board of MII shall comprise public interest directors. Next, another recommendation is to enhance transparency. The MIIs should disclose the agenda and minutes of the meetings of their board, keeping in mind their role as a first level regulator. Next is the MII's policy should adequately cover all methods of data sharing, including emails and social media, with appropriate delegation of powers for sharing data. Next recommendation, there should be continuous supervisory by MIIs of all its members by leveraging technology. Next, keeping the interest of investors in mind, the adequacy of the Investor Protection Fund and Settlement Guarantee Fund should be periodically reviewed. And another driver is mainly data and technology. So if we talk about data and technology, now uh, our participants, I don't know, many of them must be knowing that earlier in the traditional way of trading, there were on the floor trading before the technology came into existence. So digitization and innovation in technology have spearheaded the performance and capital markets. So, and now even in the capital market, when we talk about data and technology, the capabilities of cloud computing, artificial intelligence, machine learning, distributed ledger technology, and data analytics are some of the high sounding words which have now developing, which are being introduced in the capital market, will further enhance the security. And recently, in the previous discussion, we were discussing about e-security. So, in the stock market, also now this concept, there is no other alternative for us except to bring in the advanced technology even in the capital market. So, these are some the key drivers: data and technology, and strengthening the market infrastructure institutions. So with that, now I would like to apprise our participants about the legal regulations. So let me three. I mean, will I be able to share, Kritika?
Yes, sir, you can share the screen.
So let me. Fine, okay. Uh, uh, The screen which I want to share is not appearing. 1 minute. Just give me a minute.
Sure, sir, no problem.
Okay. I have shared it. Yeah. Now it is coming. Okay.
Yes, sir, it is visible.
Okay. Now, so this is basically the legal framework of the capital market. So the market regulator SEBI is in the forefront. See, in 1991, the then finance minister Dr. Manmohan Singh liberalized Indian economy, and in the same year when this economy was liberalized in 1991, there was a very big security scam in India. That was the higher, largest in the history of Indian capital market. As you must be aware, that was a Harshad Mehta scam, which broke out, which was disclosed, exposed in 1991. And at that point of time, the government decided to constitute Securities and Exchange Board of India as the main capital market regulator. And subsequently, immediately government took the step to incorporate Securities and Exchange Board of India Act 1992. This is the broadly the legal framework of the capital market. So you must have studied, our participants must have studied the original act, that is Securities Contracts Regulation Act 1956, still exists, and under that the provisions of that act are still applicable, and under that particular act of 1956 SEBI has been constituted. Securities Contracts Regulation Act 1956, and there are subordinate rules, Securities Contracts Regulation Rules 1957. And under the SEBI Act 1992, there are various circulars, master circulars, general orders, guidelines, rules, regulations have been framed. And which are those rules and regulations? That is also, if you see here, SEBI ICDR regulations 28. This is the most important, where the companies have to follow the very strict regulation when they come out with initial public offer and further public offer. That is one of the most important. Another most important regulation is SEBI listing obligations and disclosure requirements regulations. We call it SEBI LODR regulations in short. So this prescribes the regulations for compliance, for various compliances on monthly basis, quarterly basis, half yearly basis, yearly basis. Next is another important is issue of sweat equity regulation, that is for issuing shares to employees of the company. Nowadays, startups are issuing shares to their promoters and key managerial personnel. So these provisions are contained in these particular regulations. That is SEBI issue of sweat equity. Another important, there are about 2932 regulations, but these are most important regulations. Another is SEBI prohibition of insider trading. We can now, the key managerial personnel, that is manager, managing director, CFO, chief financial officers, director finance, whole-time directors, board of directors, company secretaries, they are in possession of sensitive informations because they are aware what is happening in the company. They are the people sitting in the board of directors. And on the basis of their and the main concept of this regulation is unpublished price sensitive information. So these key managerial personnel, they are in possession of unpublished sensitive information which is not available to the outside public. And if they act on the basis of this information, And if the subsequently it uh, SEBI investigates that how this information has been leaked and how the key managerial personnel has taken benefit, undue benefit of this information by purchasing shares prior to the information, which is subsequently prior to the publication to the public, and make a huge profit. There are instances happening very regularly. Even employees, because even down the line, employees are also aware what is happening. For example, in very one classic example, if I have to tell you, is regarding issue of bonus shares. Now, if the company is listed and the board of director decides to issue bonus shares, the first information available is to the board of directors and to the key employees of the finance department and company secretarial department. So on the basis of such information, if they purchase the shares from the market, because they also know that after publishing this information, price of the company's uh, share will shoot up. So they will try to book the profit by purchasing the shares. So these regulations contain very strict provisions and there are very heavy penalties. Once it is established that the employees have taken undue benefit, including director, including managing director, company secretaries, there will be heavy penalties which even runs into, and the maximum penalty under this act is 25 crore rupees. So these are the some of the regulations. Now I would like to come to the very important topic, that is social stock exchange. Let me stop sharing this and I will come to that also, which I would like to share. The Gazette of India. Okay. So we can deliver it also interactive. I would like to make it very interactive session. Okay. Gazette of India. Okay. Okay. I think it is on the screen now.
Yes, sir.
Is it visible? Okay. Now this chapter 10A was introduced in July 2022. In July 2022, the concept of social stock exchange was introduced by SEBI, and very recently the framework is also introduced. Now it has now started. Now what is this concept all about? So first of all, let me uh, take you to the definition. The social stock exchange means listing of non-profit organization or social enterprise on the stock exchange. So this is a very beautiful concept introduced by SEBI. So what is non-for-profit organization? It means a social enterprise which is any one of the following entities. Number one, the definition says a charitable trust registered under the Indian Trust Act 1882. Number two, a charitable trust registered under the Public Trust Statute of the relevant state. Charitable society registered under the Societies Registration Act. A company incorporated under Section 8 of the Companies Act 2013. Any other entity as may be specified by the board. Board means the Securities and Exchange Board of India. Now, the next definition is social impact assessor, means an individual. And now in this concept, there is a new concept which has been introduced is social auditor. So social impact assessor means an individual registered with a self-regulatory organization, SRO, under the Institute of Chartered Accountants of India, or such other agency as may be specified by the board, that is SEBI, who has a qualified certification program conducted by NISM and holds a valid certificate. So this is a definition of social. Now another definition. What is social enterprise? It means either a not-for-profit organization or a for-profit social enterprise that meets the eligibility criteria specified in this chapter. Now SEBI has specified a special eligibility criteria. So the concept, this a very lovely concept, that is a concept of social stock exchange, is mainly introduced for listing of non-profit organization, which we call it as NGO, on the stock exchange platform. Now everybody is aware that there are giant companies which are registered with the listed on the stock exchange, like say Hindustan Unilever, Reliance Industry, that everybody knows. But this is the platform created for listing of NGO on the stock exchange, and this has been introduced and very recently. Not even 1 year has passed, and slowly now through this platform, we can also promote NGOs to get them registered on the stock exchange so that they can also raise funds for social activities. Something very, beautiful concept introduced. Now, what is the applicability of this chapter? The provisions of this chapter, that is provisions related to non-profit organization, we will, for better understanding, we will call it NGO. The provisions of this chapter shall apply to NGO seeking to get registered with a social stock exchange. Now, social stock exchange is a concept which has been now separate vertical, has been developed by National Stock Exchange as well as Bombay Stock Exchange. So there is a separate platform created by NSC and BSC where they can register NGOs. So provisions of this chapter shall apply to not-for-profit organization seeking to only get registered with the social stock exchange. A not-for-profit organization seeking to get registered and raise funds through a social stock exchange. So there is a provision for only registration. Some NGO wants to only register with stock exchange, and second category is to get it registered and raise funds through a social stock exchange. So now, as according to this revised newly introduced concept, NGOs can also raise funds from the public, general public. So we collectively, we can use this, we can educate various NGOs across India so that they can register on the social stock exchange, and we will help them to raise funds for various activities. Now, which are those activities? That is also specified in the rules. This section 292D of regulation, this is under the ICDR regulations. Every social stock exchange shall constitute a social stock exchange governing council. That council is being constituted now. Now, I would mainly deliberate upon various activities. In order to establish the primacy of its social intent, such social enterprise shall meet the following eligibility criteria. The social enterprise shall be indulged in at least one of the following activities. Now let us discuss this. So which are these activities which the NGO must be indulged into? So one is eradicating hunger, poverty, malnutrition, and inequality. Second, promoting healthcare, including mental health care, sanitation, and making available safe drinking water. Number three, promoting education, employability, and livelihoods. Number 4, promoting gender equality, empowerment of women and LGBTQ communities, ensuring environmental sustainability, addressing climate change, including mitigation and adaptation, forest and wildlife conservation, protection of national heritage, art and culture, training to promote rural sports, nationally recognized sports, Paralympic sports and Olympic sports, supporting incubators of social enterprises, supporting other platforms that strengthen the non-profit ecosystem in fundraising and capacity building, promoting livelihoods for rural and urban poor, including enhancing income of small and marginal farmers and workers in the non-farm slum area development, affordable housing, and other interventions to build sustainable and resilient cities, disaster management, including relief, rehabilitation, and reconstruction activities, promotion of financial inclusion, facilitating access to land and property assets for disadvantaged communities, bridging the digital divide in internet and mobile phone access, addressing issues of misinformation and data protection. Kavita Thorat can help this platform in promoting welfare of migrants and displaced persons. Any other area is identified by the board or government of India from time to time. So the purpose of this platform is that now which I would like to deliberate, and we can have very interactive session on this. So there are n number of NGOs which are operating in our country. So through this platform, through the platform of IIIPS, we can tap the various NGOs, we can educate them, we can convince them and help them to get them registered on social stock exchange, so that in short, through this platform, we can also help our society at large, because there are, as you can see, and various activities which are covered in this, and I think definitely we can make it a very big impact on our society. So social stock exchange is, I personally feel that through through the medium of our own platform, IIIPS, let us promote this concept across India and convince. Right now, Kritika, we can collect the data of various NGOs operating in India. We can approach them and help them in getting them registered on social stock exchange.
Yes, sir.
So
I'm pretty much sure many of them would not be knowing this. Even I was not aware. This is the first time I'm being exposed to this topic. Being very honest.
yes, very, very interesting topic, uh, and there are other provisions. Let us discuss that also. The social enterprise shall target undeserved or less privileged population segments or regions, recording of lower performance in the development priorities of, that is one. The social enterprise shall have at least 60, this is one of the criteria. Social enterprise shall have at least 67% of its activities qualifying as eligible activities to the target population to be established through one or more of the following. What is that? Let us see that. At least 67% of the immediately preceding 3-year average of revenues comes from the providing eligible activities, that is the activities stated above, about 18 to 20 active, more than that perhaps. How many activities are there? Let us see. 27 kind of different activities are stated in the act. So at least 67% of the immediately preceding 3-year average of revenues must come from providing eligible activities to members of the target population. At least 67% of the immediately preceding 3-year average of expenditure has been incurred for providing eligible activities to members of the target population. Members of the target population to whom the eligible activities have been provided constitute at least 67% of the immediately preceding 3-year average of the total. These are the criteria. Now, what are the requirements for registration of NGO? So, a non-profit NGO shall mandatorily seek registration with us. Now, the word is shall mandatorily seek registration with a social stock exchange before it raises funds through a social stock exchange. So, registration with the social stock exchange is now mandatory before the NGO raises the funds. The minimum requirement for registration of NGO on a social stock exchange shall be specified by the board from time to time. So that guidelines is separate, that we can deliberate in a separate session because it is a separate guidelines, but we will deliberate on this platform. So fundraising by social enterprise. Now these are the financial product. NGO may raise funds on a social stock exchange through issue of zero coupon, zero principal instrument to eligible investors in accordance with the applicable provisions of this chapter. Donations through mutual fund schemes as specified by the board. Any other means as specified by the board from time to time. Board means SEBI. So SEBI at regular intervals will bring some sort of amendments for NGO. A for-profit, there are two concepts, NGO not for profit and NGO for profit. A for-profit social enterprise may raise funds through, these are the financial products, issuance of equity shares on the main board, SME platform. Now there is a SME platform also, that is a small and medium enterprises. Now both the stock exchange, that is NSE as well as Bombay Stock Exchange, they have created a separate platform for SME. Now there is a different guideline whereby the small and medium enterprise companies which fall under the SME segment, that is small and medium enterprise segment, they can raise the funds, they can list their equity shares on the SME platform, which is a separate platform. So there is a main board, that is the companies like giant companies like Hindustan Unilever, Reliance, Tata Groups, and there are, if I tell you the statistics, about 5,400 companies are listed on the main board. There is a second type of board, that is SME board for SME companies. According to me, the latest data, as per the latest data, about 478 companies are already listed. SME platform is also a new platform, but already 478 companies are already listed on this platform. And now, similarly, this platform is specially created for NGOs. So there are, according to me, not thousands, maybe lakhs of NGOs are operating in India, and it's a very, we can say a new kind of business. Even if we look at from the business point of view, it is also a very good business. So lakhs of NGOs are operating in India. We can educate them and help them in getting them registered on this platform. Explanation says securities issued for profit social enterprise shall be listed and traded under the applicable segment. That is an explanation we will not. There are certain restrictions for raising funds. So what are the restrictions that is specified under this regulation 292H? A social enterprise shall not be eligible to register or raise funds. A. If the social enterprise or and any of its promoters, promoter group, or directors or selling shareholders are debarred from accessing the securities market by the board. So if any of the promoters or directors have been debarred in the past, they are not eligible to get it listed. If any of the promoters, directors, or trustees of the social enterprise is a promoter or director of any other company or social enterprise which has been debarred from accessing the securities market, these are the restrictions. These are the financial product issuance of zero coupon, zero principal instrument. Zero coupon, zero principal instrument shall be issued only by a not NGO registered with the social stock exchange. The next provision deals with the eligibility for issue of this financial product. So I am not deliberating in detail on that. So we can have a separate session and we can deliberate on this. The next contains about procedure for issue of zero coupon. So procedure and much detail we will not talk here. So basically what I wanted to educate so basically what I wanted to educate through this platform is there is a new concept of social stock exchange and we can tap huge number of NGOs. We will educate them how to get registered on the social stock exchange and for their activities for which the NGOs have been created by various groups, so that we can help them in raising the funds for all these kind of activities. So that is what especially today through this platform I wanted to highlight and educate. So my intention, rather my intention is through this platform, let us come together and let us collect the data of various NGOs which are operating across the country. Now, I also do not know how to get the data of NGOs. The idea is let us approach these NGOs. We will educate them. We can jointly prepare a special PPT for this and we will give presentation, and so that we will help them to get them registered and we will help them to raise the funds from NGOs and help them in their activities also. So this is what all about I wanted to specially educate in today's session. Thank you.
Thank you so much, sir. That was a very new concept, I think, for all of us about the social security exchange. Does anyone have any questions related to this? So I do have one question.
Yes.
Regarding the relatability of this stock exchange and the taxation provisions, because when we hear NGO, it is by default that 80 to 90% of NGOs do have tax exemption, that is 80G or 80E or
Yeah,
the relevant ones.
that is compulsory. Yes.
Yeah. So, and under those circumstances, now when it comes to stock exchange, it will not be donation; it will be an investment. So even there, will there be any exemption of the taxation? Or
Yes. There will be exemption. Yes.
okay. So all I could think was,
So that is the beauty of this concept.
yeah.
So
Okay, so my investment will not be taxable.
no.
Okay, then that
So
will
what
be a very good
not
investment
taxable means
option.
as per the 80G of income tax, whatever as per the provisions of 80G, that provisions will apply.
Yeah.
It is not
But
that
here it is in
100%.
the stock exchange, right? Like I'll be getting the profit also out of that.
See that I mean taxes and provision, that concept, I mean that has not yet been introduced. I mean
Introduce.
not
Okay.
clear. Not introduced means it is not clear what
Okay.
how it will happen. So let us work on that also, because I am also
Yeah.
not very clear on that aspect, to be very frank.
I could think of BCCI as a best example because that's a trust, and they are
Yes,
mainly
yes, yes, yes.
concentrate on the cricket, nationally recognized this one, and it connected all the dots. I think that
Yes,
NGO
yes,
for
yes. No,
me,
no,
that
your
trust for
question
me
is
qualified
valid.
all the
Question is valid, but according to me, as per the ATG provisions, whatever benefit is available, that will be applicable.
available. Okay. And also I couldn't see those educational institutions anywhere because IAPS India is also an NGO organization. So I was looking for
No,
educational industry.
in that case, we can always approach SEBI, and we
Hmm.
will try to get permission from SEBI that we
For
should also
educational
do this.
institution.
These are the activities which we are doing,
Hmm.
and but in that case, I think ATG
Some or the
certificate
other,
will have to be obtained. So
yeah.
it starts with section 12 double A of Income Tax Act. First, we have to
Mm-hmm.
get that certificate from
Mm-hmm.
income tax, and then
Mm-hmm.
maybe after, I think it takes about 1 year or 1.5 years to get ATG from the
Okay. Yeah.
charity of commissioner.
Mm.
Because 12 double A of income tax certificate is from
Mm.
IT department, but
Yes.
ATG is normally given by commissioner of charity.
Yes. So we'll
So
have to prove certain things that we are doing
yes,
for
yes,
charitable purpose. We do not have profit
that,
and all the
yes, yes, yes,
documentation. These
yes.
days, even temples do have that ATG, and they'll be putting in the board that you have
All,
ATG, all the
basically,
benefits.
it should be all it should be covered under the definition of non-profit organization.
Yeah,
Then only it will be allowed to be registered on social stock exchange, and then only after registration only you can raise the funds.
funds. Okay.
So this is a very beautiful concept. Even taxation provision, we can always research on that, and I will do that.
Yes.
We will do that. But this is
Yeah,
one
because
concept where a triple IPS can tap this, because no, very, I
sure,
think
sir,
very few
sure.
are aware. Few are aware.
Yeah, and I was also simultaneously Googling like how many are registered under those. Like hardly around 10 have registered, that's all.
Very, very few are registered. I don't know right now. I have the
Yeah,
information.
over 20, I think. Yeah, there is one from CNBC TV. Around 20 have registered. Yeah, over
Because
20
no,
different.
there is no awareness. That is the issue.
Yes.
There is no awareness. But,
Some Development Management Foundation, Gramalaya Trust, Green Age, Graysim. So
yes,
I'll
yes,
share that
yes.
screen because it is really nice. One second.
I don't know. So,
Yeah, the if you could see the screen, the list is here.
okay,
Development Management Foundation. They do educational institution founded to create, strengthen, and establish development management.
right.
Okay. They are an
Okay,
educational institute. Okay. Gramalaya Trust, Green Age, Grace Sim Learning Foundation, Kushi Vikas Ka Gramin Parikshan Sanstha, Lighthouse Communities, Masum Trust, Missing Link
right.
Trust, Mukti. Yeah. So there are
For
there are only
those
a
who are
couple of them.
aware, those professionals who are educating, uh, with whom they are associated, they are getting it registered. So we can also do.
Yes, there is an legal society also. So, Voice Society, voluntary action group of aca- academicians,
Yes,
professionals, and volunteers who works to raise awareness amongst Indian consumers about their own consumer rights.
right. Okay.
Yeah. So they have sneaked in some place.
Yes, yes, yes. So you can start working on that. Rather, not you. We can start working on that.
Yes, sir. Yes, sir. That's true.
Great.
Yeah. Any questions from anyone? I don't think there are any questions. Thank you so much, sir. It was really informative. I personally learned a lot about this topic, and I think this is a booming topic, and this definitely qualifies for more awareness so that more people could come up and take this take this benefit of the platform which the government has given to us. A great initiative, and really, I could say
Yes,
that
yes,
really thank you
absolutely.
for bringing this up and sharing this one with us,
Thank
Gaurav.
you. Welcome.
Thank you, sir. Yeah, Soumya Datta, please.
I was saying that maybe we can post about this on LinkedIn, so
Yes.
Yes, 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 yes,
so
yes.
people can know. Because I have many friends who are actually social work students or social workers, so they will get to know about that.
Yes, yes, yes. And it's a good platform for NGO to raise funds.
Hmm. Yes, definitely. Yeah,
Great.
okay. So, thank you so much, sir. Moving further, we have Gokul here with us, Gokul Krishna with us. Let me take the privilege of introducing him to this gathering. He has completed his LLM from Bangalore, and currently he is working as assistant professor of law in Bangalore, Reva University, wherein he teaches subjects like constitutional law, CPC, CRPC, the procedural law subjects, followed by consumer law and other related subjects, in addition to music law and others, to the students who are in Be Vocal and other vocational courses. In addition to this, he has earlier worked in law firms related, wherein he has handled a profile related to real estate. He has done contracting, contract drafting, and other allied work. And with the great experience of 5 years, he has proved himself in all the areas and in all the profiles that he is being assigned as an exceptional candidate. And I have been knowing him for I think more than 10 years, or yeah, more than 10, 11 years I've been knowing him. He's been the same person, enthusiastic, both in academic as well as in the extracurricular activities. And today we have him here speaking about the relevancy of Indian constitution in today's era. Like, though the constitution was drafted so back early, like 1947, even before that, the foundation was laid and it was all done. So how even in 2024 the constitution is relevant, because relevance of constitution is a very much important factor, important aspect for all of us, because all our laws some or the other way owes its origin to constitution, or vows its surrenderance, or vows its ownership, or whatever it is. It is constitution at the end of the day. Any law against constitution, it is constitution. So it is very important that the constitution should be relevant even today. The best example I could give is today I was researching about the Domestic Violence Act 2005. Sorry, 2000. So wherein I got to know that earlier, when the legislation was initially drafted and it was assented, the act said that a female can give only a female can give complaint under that act, and against only males. That was questioned in Honorable Supreme Court, and it said that it violated the Article 14 of the Indian Constitution. And the Indian Supreme Court, in that Hiralal case, it struck down the word adult male. It said that a female can file a case of domestic violence against any person, irrespective of the gender, because it said that it has to be in consonance with the Indian Constitution, that is Article 14. So that way, I was like, yeah, this is so correct, and I thought that Gokul is going to give a very good talk today on this one. And yes, happy learning, everyone else. And Gokul, it's over to you.
Good evening. Thank you, Madam Kritika. Good evening to all the intellect learners of the evening. As introduced by Kritika Madam, myself Gokul, currently working in Reva University as assistant professor. My learning towards law is still going on because there's no end. For everyone, it applies. But what I have understood as a law learner is there are so many definitions for law, LAW, law. But what I found for myself is law means to learn. Learning is not just enough. Learning law is helpful, but it will be helpful when we apply. So A stands for applying. Learn, apply. But how do apply? How do we have to apply? Again, W, wisdom, with wisdom. So law stands for learn, apply, and apply with wisdom. This is what law defines for me. Friends, today we'll be understanding the importance of constitution in the modern era, how it is working, what is the requirement, especially Indian constitution. When we speak about Indian constitution, we all know that it is world's best constitution, though we have taken aspects from so many countries. For example, emergency provisions from Germany. From Canada, we have taken the governor appointment. From Russia, we have taken fundamental duties, so on. So it is a patchwork. When B.R. Ambedkar ji was asked in the interview, when he was coming outside the Constituent Assembly, one of the media persons asked him, "Don't you think that Constitution is a patchwork?" It was asked by a press person to Dr. Ambedkar ji. So when it was asked, Ambedkar immediately replies, posing his hand towards the media person, stating that, "Gentlemen, maybe this is a patchwork, but it is a beautiful patchwork. Despite of being a patchwork, this has become a living document. Why? Because it is giving life not only to the people but also to so many acts. So many acts, legislations are alive today because of constitution. And we have this conception where most of us think that constitution is a dry subject. We are not able to understand. I have found this kind of understanding with the students in my like 5 to 6 years of experience. But my dear friends, I would like to tell, this is not dry subject. We can't tell it is a dry subject at all, because it speaks about Article 21, right to life and liberty. A document which speaks about life, how can we say it is dry? It is giving life to the entire functioning of the country itself. So it's our duty to understand that constitution is a living document which is enabling us to live as well as lead our life in a peaceful way. As we discussed today regarding data privacy, as sir spoke about capital market, it is all general, yes, accepted, but we can't escape from linking those aspects with the constitutional aspects, because again data privacy comes under Article 21, as madam told, and capital market investments, making money, again it is linked to Article 19, right to profession. In Article 19G we have right to profession. So anything and everything can be linked to constitutional provisions. Right to information, again when we speak about right to information, it's Article 19. Everybody have the right to get the information from the government. We have RTI Act. Maybe RTI specifically not mentioned in the constitution, but however it comes under the purview of Article 19. So like this, constitution is something which is above all. It is law of the land, and it is like sun, and all the other laws are revolving around it. So this is very important that we have to understand. However, I would like to speak about the concept of basic structure of Indian Constitution, because there are so many aspects with respect to Indian Constitution. As we know, Indian Constitution is combination of substantive law and procedural law. It is like procedural aspects are very minimum. It is a substantive law in its origin, but however we can find the procedural aspects here and there. For example, Article 311 speaks about procedure. For example, when an IAS officer or a civil servant is been removed or reduced in the rank position, what is the procedure that has to be followed? The first procedure which constitution again speaks is about giving him right to be heard. That is also part of procedure. Likewise, we can see few aspects, procedural aspects in constitution, but however max to max everything is substantive in nature. But the role of judiciary, in protecting this constitution is very, very important, as we all know. How it has been protected so far in modern world, for example, especially when constitution came, it was in a vulnerable situation, but however judiciary was the one who is the one which took the role of protecting it. Its role itself is to protect the constitution. Why? Because in this land we have this concept, dharmo rakshati rakshitaha. It is a philosophy which is not exceptional to this aspect also. Why? Because if we protect constitution in turn will protect us. As we know, we the people of India, constitution starts with this word, we the people of India. So constitution is protecting the people, accepted, but if we won't protect the constitution, then how will the constitution protect us? As we can see Ambedkar ji's statue everywhere across the country. It is what I have understood personally. He holds constitution in his left hand and points towards the people, right hand. He points the index finger towards us. It indicates that it is we people who are responsible to uphold that book. He is holding holding the constitution in left hand and posing the finger towards us. That means this book is in our hands. It is our responsibility. So if we protect it, in turn, it will protect us. That is what the philosophy is. Likewise, how did judiciary played an important role in protecting the constitution? As we know, legislators at that time, during Indira Gandhi's period, we all know this. It was a situation where constitution was in a vulnerable situation where they changed the names of the part itself for the political aspects to get the political gains. And how judiciary was successful in protecting the constitution. Though that aspect is not mentioned in the constitution, it is protecting the constitution. That is nothing other than basic structure of Indian constitution. Nowhere mentioned, nowhere seen, nowhere understood, but still its existence is felt, and its existence is protecting the constitution in return. As we know, the concept of basic structure of Indian constitution, which came up from Keshavananda Bharati case. Prior to that, did legislators have the power to amend the constitution? Yes, they had. But did they have the power to amend all the part of the constitution? Again, yes. Initially, in the case of Shankari Prasad case, it was held. Yes, Parliament can amend any part of the constitution, including fundamental rights. And in Sajjan Singh case also, it was confirmed. Yes, they can amend it, including the fundamental right. But in Golaknath case, Constitution, the Supreme Court again reversed its judgment, stating that Parliament can amend any part of the Constitution except Part 3 of the Indian Constitution. So Parliament again, the power of amending the Part 3 was taken back by the judiciary from legislature. So what did legislators do? The Parliament do. So Parliament introduced an amendment, that is 24th amendment, which changed part 20 of Indian constitution, which speaks about amendment, from procedure of amendment to what? Power of parliament to amend the constitution. And it disconnected article 13 of Indian constitution, which speaks about what law is, and article 368, that is relating to amendment of the constitution. It was disconnected. So by this, again, parliament gained the power of amending the entire part of Indian constitution, including fundamental rights. This is what happened. So what major idea of legislature judiciary was, it had the intention that legislature will not misuse the power by amending fundamental rights which might affect the people. And again, parliament by this amendment again gained the power of amending fundamental rights. And what judiciary did again, it accepted, fine. It told you can amend any part of the Indian constitution, including fundamental rights, accepted. And by this stage, it shot a Brahmastra. It was like, we can say it is Brahmastra, that is nothing but basic structure of Indian constitution. So this is smart judicial innovation, we can say. It is judicial innovation by itself. Especially in India, this basic structure of Indian constitution, we can't find any other country. Maybe they are following, seeing us, but Indian judiciary was the first judiciary to speak about basic structure of Indian constitution in Keshavananda Bharati case in 1973. So what did basic structure of Indian Constitution mean at that time? Even to this day, we can amend any part of Indian Constitution, including fundamental rights, Part 3 of Indian Constitution, but that should not disturb the basic structure of Indian Constitution. Now the question is, what is basic structure of Indian Constitution? It is nowhere defined. It is nowhere told that this is basic structure of Indian Constitution. It is a open definition, which is like we have to understand by judicial interpretations and judicial pronouncements. So by this smart move, judiciary is protecting and has protected and is still protecting the constitution. Why? Because ultimately the entire freedom struggle happened for one part of Indian constitution, that is part 3 of Indian constitution, fundamental rights, right from article 14, right to equality, and article 19, right to speech and expression, right to freedom, and article 21, which is very important, which is called as soul of Indian constitution, and article 32, heart and soul of Indian constitution. If something goes wrong, if our rights are being violated, then what do we have? We have the right to go and approach the judiciary as per article 32, again, which gives 5 writs: habeas corpus, mandamus, certiorari, and quo warranto. All these 5 writs are there for us to approach the judiciary directly and get the remedies and lead a peaceful life. So this is ultimate purpose of having constitution, which is very fundamental aspect that every law student has to know. As you know, people, this is people's constitution. Indian constitution is called as people's constitution. Why? Because when we got independence, it was we who drafted Indian constitution. It was not Britishers. But there are certain countries, for example, we have Sri Lanka, Ghana, Kenya. Those countries where are the examples wherein they were colonized, but they did not get the opportunity to frame their own constitution despite of getting independence. Britishers in their parliament, they framed constitution for these countries. So Indian constitution has a special status and special stand in the entire country, in the entire world, wherein we ourselves framed the constitution and we are following it. That's the reason the word that we use, we the people of India. So that doesn't mean someone who was there long back. No, it's not that. It is we, still it is applicable present. Even I, you, everyone is in this country are part of constituent assembly directly or indirectly because of the usage of we the people of India. Though the preamble, as we know, coming to the preamble aspect, though we know that preamble is also an ideology which has been taken from so many countries. For example, French Revolution, we have taken the concepts. Fraternity, we have taken so many aspects, equality, liberty, all those things were taken from the French Revolution. But yet Indian preamble is been considered as a special preamble because of its words that is being used, because we have the word unity in diversity. This is very, very important. Though we have so many religions, so many ethnicity, we are diverse in nature, but still we have to be united. That's what Indian preamble tries to make us understand and lead our life in this country in a peaceful manner. So my dear friends, I would opine that we as Indians, it's our responsibility to make sure that Indian constitution is been upheld, contributing with the judiciary's footsteps, because judiciary, as we say, there are many concepts along with the basic structure of Indian constitution. Many concepts are been emerging. For example, judicial activism, maybe judicial activism, judicial overreach, judicial review. We have the concept of judicial review. All these things are those tools which have been used by judiciary again to protect the Indian constitution and ultimately for the purpose of interest of the citizens. So by this, I would like to end my small talk regarding Indian Constitution. Thank you, one and all.
Yeah, thank you, Gokul. That was like really informative regarding the certain aspects. Like, see, for a third person or for a common person, an Ambedkar statue is nothing but a man standing with a book and his finger directing at something or pointing at something. But the depth of the meaning that it holds, I think that has to be understood by everyone. So that, I think, that has to spread a lot. Only then the emphasis or the principles of the constitution that we embody has to be understood, or only then the constitution will get the value, or will get that significance it deserves.
Yes, yes. Thank you.
Yeah.
And I would
Anyone
like to
has?
add, another one, understanding what I have come up with. Because, for example, we spoke about basic structure of Indian Constitution, nowhere defined accepted. But still, if we see the logo of Indian judiciary, Indian judiciary has the quotation in the bottom, which tells that where there is dharma, there is victory. Yato dharma stato vijaya. Where there is dharma, there is vijaya. Where there is truth, there is victory. And above that, we have a few blocks which represents people. And above that, we have um, the parliament, the emblem, which we can compare it to the parliament. And above that, that is Indian emblem. Above Indian emblem, we have again Ashoka Chakra, that is Dharma Chakra, Pravartana, what we say, Dharma Chakra. So that indicates whatever government does, whatever action government does, above that again, there is someone who is there to review whatever government has done. That is again concept of basic structure. The entire logo itself, in a way, it makes us understand that dharma again prevails, the truth again prevails. So that is what judiciary is trying to uphold, the truth. Though there are so many loopholes in our country, judiciary, we have so many complaints. Maybe it is collegium system or corruption activities that we have. Right from the lower courts, they are demanding for money for the appointments. All those things has to be checked. But however, the main role of Indian judiciary has extended in the modern day era from interpreting the law. Initially, it had the role of interpreting the law. Now it has taken up the role of protecting the constitution as well as protecting the interest of the people by judicial innovations like basic structure of Indian constitution, judicial activism, and so many other aspects.
Yeah, I think, yeah, what you said is very correct. Here, I would like to quote that power corrupt and absolute power corrupts
Yes,
absolutely.
yes.
So it is something I think we have to dwell with it. There is no escape mechanism. Though we can face it, though we can overcome it, but it is something that we cannot avoid in our system. So if everyone becomes good, then I think even that is something will not be digestible in our society. So what if everyone becomes so good? So that is somewhere that is not going to happen. We cannot
True.
expect that one, but we should be ourselves stating that no, I'll not give bribe, I'll not take bribe, I'll do that, I'll do this. Once we set a level of principles for us, I think that would serve the purpose. And
True.
also I echo with you on the legal the power that the judiciary holds. I could recall one more judgment related to the POSH Act. So this was from the Madras High Court, wherein one female employee had filed a case of sexual harassment against another female employee. So this was questioned. The POSH committee, it told that no, we are going to reject it because the act says that the complainant has to be female, but the other person has to be the harasser, has to be the male. So we cannot take that. When it reached to the High Court very beautifully said that yeah, legislators may make mistakes sometime. We are here as a judiciary empowered by the Constitution of India to correct all the mistakes. Just because somebody has vomited something or something is not done, when it comes to validation or when it comes as a question in front of us, if the court opines that yes, that's a wrong thing, then we are going to strike that out. So yes, that even that judgment, I read that judgment entirely, and it has very beautifully quoted the constitutional principles, and it has justified. The judge has justified himself that on what authority he's interpreting that particular provision. So it's somewhere the other, this absolute, or I could say this power to the judiciary is really good on the perspective of the constitutionalism. Yeah. Any questions for Gokul on the subject that he has spoken about, the Indian Constitution, the relevancy, the powers, the or I could say the relationship between the politics, I mean, the parties, the government. Yeah, I think there are no more questions. Thank you, Gokul. It was really informative, and of course, it was a very different perspective of learning Constitution for all of us. And thank you so much.
Thank you. Thank you. Thank you, one and all.
So with this, we are done with all our 6 presentations. And one thing that I have to say from the bottom of my heart is, though the number of
I
participants,
I have a
yes,
question, a very small question.
yes, sir.
He was talking about basic structure of the constitution and he rightly said there is no specified definition what exactly is the basic structure. So I just even at this level also after so many uh, years of experience, the question still remains in my mind. What exactly is basic structure? If you can elaborate by giving some say decided judgment other than uh, Nanda Bharti, because in other cases also these questions have come up before Supreme Court also.
Yes, yes. In Minerva Mills case also the same was upheld the basic structure of Indian Constitution. We can see the definition of judiciary trying to interpret what basic structure of Indian Constitution is. Like again, and our general understanding regarding basic structure of Indian Constitution is nothing but not to disturb the very essence of the human values, as preamble speaks about equality, justice, and liberty. So all those things has to be upheld, and Parliament's Act, the very purpose of having the basic structure of Indian Constitution is nothing but Parliament should not act in a way where it disturbs the interest of the people because of the political gains or whatever it might be, because this happened, and because of that again the concept of basic structure of Indian Constitution emerged in our country, which is still protecting, and probably yes, this will be the main tool, or like what we consider Brahmastra. It is like it will protect us throughout our sustenance as a country.
Okay, okay. All right. Thank you.
Thank you, sir.
Thank you, Gokul. Thank you, sir, for asking that question. Yeah, moving further, coming back to where I was, one thing that I have to appreciate all of us and all of us here, and thank you for everyone for the fact that though the volume, like we had around 12 to between 12 to 10 people in this conference, but nowhere I found this impacting any of our speakers' energy level or speakers' mood. They always had this I could say an energy or the intention or the attention that they gave. It was like I'm pretty much sure all of you would have presented it in the same way, though we had 100 presenters here, the 100 people, 100 audience, 100 people listening to us, or a good number of audience here. There was never a second where the motivation or the attention or the interest of the speaker dipped for a second. I think that is the beauty that we should really appreciate, and you will not find this quality in everyone. People will be like, oh, there are only few people, I'll let me take it halka halka, let me speak it a little, let me grasp, let me swallow this, let me not tell that, let me not tell this. But nowhere I found anyone doing so, and I'm really thankful and highly indebted for all of you, especially speakers, for doing this one, for being so kind and so intellectually positive to share the knowledge. I really appreciate it from the bottom of my heart. And trust me when I say that this is one of the best qualities that you possess as a speaker or even as a human being. Moving next to all my audience here, thank you so much for being there for both the days and listening very patiently, and also sharing your thoughts via WhatsApp message or in the chat box. Though people were like not okay with unmuting themselves, which I'm like, okay, it's their personal choice. But dropping messages in comment box, and also I got few pings in WhatsApp as well that the session is going good, and we got to learn so much. Some people are even asking for the LinkedIn profiles of the speakers. It was like really great. Thank you so much. You never made me feel that there were less audience. I could say that the quality mattered over quantity. Thank you so very much for the kind support. Again, I am highly indebted for all of you. And moving next, when we had announced the awards for the presenters. So the outstanding research paper, I would like to give it to the person who has done immense research on the topic that he presented. And I had said this in the starting of the session also, like he also referred the IPC section as well as the Nyaya Samhita section, Bharatiya Nyaya Samhita section, BNS sections. So I think that required a lot of energy, a lot of time to do. So we'll be presenting outstanding research paper to Soumya Datta. Congratulations on this one. And moving next, it is Premier Presenter Award. Yes, I would like to give it to the presenter who presented really good and who was, who like, the moment she started it and the moment she ended it, she had the same energy, and it was so very beautifully explained by her. She maintained the decorum, eye contact, everything. And that's to Kavita. Congratulations, Kavita, on this one. And we are giving
Thank
another
you.
2 awards. That is a special recognition award, one to Ganesh. And he was also really good. And I know of all these presenters, I have troubled him a lot. I'm like, add this one, add this one. Like I had sent him so many inclusions, so many corrections to do it very patiently. He did everything. We also connected and we discussed, and he has carried out the session really very good. So this one is to you. And also
Thank you,
to
ma'am. Thank you very much.
and also to praise, as I said, she gulped all the Indian names. I'm sure, because even for me, I was like, how do I pronounce your name? There were a few other people also yesterday. I couldn't even read out their names, but she was very good with all our names, and she very well handled all the sessions, and she added her own touch to the content that I shared with her. I'm like, yeah, so this is something new that I did not write. So thank you so much, Press. So this is for you. And all your certificates will be reaching you tomorrow, or please bear with us if it becomes day after tomorrow. And to all the participants, the e-certificates will be shared to your registered email. And I would be really happy if somebody could share your experience, either maybe speakers or participants, because if you have any suggestions too, that would be really good. And I would request your suggestion in knowing one part, that this happens many of the time. Even this time, like, we had good number of registrations were bang on. So many inquiries on how to present papers. I want to be there, I want to moderate the session, etc., etc. And at the end point, when the time was approaching, nobody turned up. Like, I feel that I'm lacking that capacity to converting the people to attend the sessions. So please guide me on that. And also, if you have any suggestions, the platform is open.
Ma'am, I would like to say that I am very grateful that I got the chance to present here. And this session, even yesterday and even today, the session was very interactive. Like, everyone participated, we asked questions and all. So it was an excellent experience. So I would like to convey that.
Thank you. Anyone else?
Uh, Let me tell you that this was this was really a very good beginning, and as I said, journey of 1,000 miles starts with a single step.
Yes, sir.
So today we have taken a single step, and I am very confident that one day there will be more than 1,000 participants in our forthcoming programs, and we will organize for even say different topics.
Mhm.
Definitely, we will organize, and there will be much more participants. Let us hope that,
Yes,
and
sir.
with collective efforts, definitely we will achieve it.
Yes, sir. There are registrations. People ask, they ping,
Okay,
they write email, they do everything. But on the day of session, nobody turns up.
so that is where the implementation is very important.
Yes.
So people think Saturday, Sunday is a time to enjoy.
Yeah,
Maybe
and
that
weekdays it's college time, our work time. I don't know where do I find a time which is no neither Saturday, Sunday, or neither a working day, neither a college day.
right. No, we will take it forward and let us make it a big institute.
Sure, sir. Thank you, sir. Thank you so much. And I should especially thank you that you extended your support, and you were always just a ping away and always supporting. And thank you so much, sir. I have really no
Welcome,
words
welcome.
to state here. Like, really, thank you so
Thank
much.
you, thank you. Welcome.
Yeah, I think, yeah,
Uh,
Ganesh.
Thank you, madam. Thank you for bringing this opportunity in front of us. And we have worked on the topic which are allotted to us. And it was a wonderful experience to me, especially guided a lot to me. And I have connected to you from 3 years, madam. It is very happy to participate in these kinds of sessions. I'm very grateful to you, madam. Thank you.
Thank you, Ganesh. Thank you. Yeah, Kavita.
yes, Kritika. First of all, I would like to thank you to you that you have created such kind of platform, and you gave us chance for this session and all that. And every speaker is having different topic and different aspects. So many there are, we can say, Jaydeep Mehta's topic. It's really, first of all, I haven't any idea about these things. Though I am handling SEBIs and all that, still I got new perception, we can say, for that topic. And everyone is very interesting, spoke very interestingly, new things. And further, I would like to mention that Gokul Krishna's first elaboration of law, it's really amazing, it's really catchy, and
Yeah.
everyone is spoke in that spirit. Nowhere I think that I'm getting lazy and all that, not at all. L- Yesterday and today also. So thanks to every speaker, and thanks to you and listener who are listening yesterday and today. So we
Yeah.
will expecting more than that. So this is our first step, we can say, in it is positively going ahead. So for your next, whatever the sessions, whatever the conference or your project, for that I'm wishing very much best of luck.
Thank you, Kavita. Thank you so much. And with your best of luck, I would also expect all the support.
Yes, yes. Support always be there. Whenever you need it, just ping me. If I'm
Sure,
available,
sure,
I'll do that. No issue
sure,
for that.
Kavita.
But
It's
ping
my
me
privilege.
whenever you need help.
Sure,
Yes.
sure, sure.
Yes. Thank you. Thank you all.
Thank you. Yeah. So anyone else? Okay. I hope you have filled in the attendance day for attendance day sheet two. Please do fill that if you are the participant, and if you have not filled it, let me paste it again. Okay, yeah. So thank you everyone for being with us for 2 days. I hope this journey was a lot of learning to you, and we are winding up with a very positive note. A great thanks to again Jaideep sir for participating, for organizing this session with us, this e-conference with us, and making it a grand success. And also to all the speakers, Ganesh, Kavita, Gokul, Praise, and also Soumya Datta for dedicating all your time and preparing for the paper and presenting the paper here, and also like more than 4 hours each day, 3 to 4 hours each day, spend that too on weekends. Also to all the participants, I hope we made your weekend a great weekend. Thank you once again, from the bottom of our hearts. This is on behalf of Jaideep sir too. And yes, so we'll keep posted about the next events, the next thing happening. And yeah, we'll meet you in the next one. Thank you.
Thank you.
Thank you, madam.
Thank you, madam.